Look, Mr. Gregory, I'm not expecting for you to respond. I'm going to set this case for a pretrial conference on the same date as the other pending cases. You are facing a lot of jail time in these cases, and I don't want to hear any excuses from you today or at any time about why you're driving. I'm fed up with you! Constantly being in this courtroom driving against court orders while pending cases are happening. This is constant, well before Mr. Loftus was ever involved in representing you. If there's one more incident between now and the next pretrial where you come in to this court having gotten another citation, you might as well just walk to the jail. I'm fed up with you. I can't believe I'm letting you go. I can't believe I'm letting you walk out this door. It's constant with you. And I don't get why I keep being so generous to someone who just thumbs his nose at me. Get your client out of here. I don't want to see his face until the next pretrial. Bond is set, $5,000 personal recognizance, not to operate or be in the driver's seat of another vehicle. Thank you, Mr. Loftus.
Now you can see why I actually enjoy watching this judge in action. He's fair, he's firm, and he keeps complete control of his courtroom. He sets the standard and makes it clear that order will be maintained. In fact, we're staying right here for the next case. What makes this hearing especially interesting is that it's happening in front of a group of young students on a courthouse field trip, and they're about to witness firsthand what happens when someone disrespects the rules and discovers the real meaning of consequences.
Okay, Ms. Sullivan, did you understand all of the rights and plea options I just explained to everyone?
Yes.
Do you have any questions regarding any of those?
No.
Do you recall receiving a copy of the
Yes.
citation that was issued on November 1st, 2022?
Yeah.
Okay. You're charged with 2 counts. The first charge is driving under suspension. That is a first-degree misdemeanor. If convicted of this offense, you face a maximum 180 days in jail, a maximum fine of $1,000, and I could impose a license suspension of up to 1 year. And this is a 2-point violation. So do you understand the consequences you face if convicted of that charge?
Yes.
The second charge is use of headlight beams. That is a minor misdemeanor. That is punishable by a maximum $150 fine and court costs. Do you understand that?
Yes.
The officer, I don't know why he checked not applicable on the ticket, but it is very applicable. If you need to provide the court proof of insurance that on the vehicle you were driving on November 1st, 2022. If you're not able to provide this court proof of insurance on the vehicle you were driving that day and are convicted of this offense, you do face a mandatory non-compliance suspension with the Bureau of Motor Vehicles. Do you understand that potential consequence?
What did you mean by non-political, whatever the fuck did you say?
The judge didn't revisit her case that same day, but it really didn't matter. She was there to turn herself in on a bench warrant regardless. With that matter set aside, we move on to the next case, which unfolded just last week in Judge DeSanto's courtroom. This hearing quickly took an unexpected turn. The defendant began firing off accusations, labeling nearly everyone in the room as being biased against him. But Judge DeSanto wasn't having it. He cut through the noise immediately, making it clear that the courtroom runs on facts, not unfounded claims.
What do you mean by non-political, whatever the fuck did you say?
Take her into custody. Did you just use the F word in front of these kids and in front of me? Did you just do that? Take her into custody, go down in jail, and then think about what you just said to me in this courtroom in front of these kids And then maybe, just maybe, I might take your case up later today. Okay? Go. Get out of here.
Sir, no.
Get out of here.
This case is actually quite unusual. Typically, when an attorney steps away from a case, it's at the request of the defendant. We see this often in so-called sovereign citizen trials, where defendants dismiss their lawyers in frustration, hoping the next attorney will validate their unconventional arguments. But this situation is different. Here, the tension isn't about ideology, it's about legal strategy. The defendant and his attorney reached a fundamental disagreement on how to move forward, and while it is always the defendant's right to choose the direction of their own defense, an attorney also has professional obligations. If a lawyer feels that a client's motions are frivolous or that pursuing a particular path would compromise their legal license, they have every right to request to withdraw from the case. In this instance, it appears the attorney simply wasn't willing to stand behind the defendant's approach, especially given the added challenge of the defendant trying to represent himself alongside outside advisors.
Case number 25W700388, the state of Michigan versus Bradley Peterson. Okay, counsel, your Mr. Pervin Keller, your name for the record, please.
Good morning, Your Honor. Yvonne Parabon Keller, P84328, appearing on behalf of Mr. Bradley Peterson, who is present today in the courtroom.
All right, thank you. And Mr. Peterson, for the record, please.
Brady Thomas Peterson.
All right, thank you. And Ms. Bella, your appearance for the record, please.
Good morning, Your Honor. Michaela Vella on behalf of the people, P87185.
All right. And so today is the date scheduled for a probable cause conference in this matter. And counsel?
Your Honor, I had the opportunity to speak with Mr. Peterson in the breakout room, and this is something that the court may be aware of, and I am not. Mr. Peterson had recently come out of being incarcerated for the purposes of these proceedings. He got out on bond, and that was arranged. Mr. Peterson and I had discussed a number of things in the breakout room. We discussed going forward with strategy in this case, and Mr. Peterson had informed me that he had filed a motion with the court to remove the judge from this case. And regardless of whether that motion had been filed or not, or whether he intended for such a motion to be filed, I advised him that I was not comfortable with doing so and that I did not agree to do so for the purposes of this case. And as such, him and I discussed that this was going to be a stopping point in going forward with representation. And as such, we parted amicably. And at this time, I would ask to be allowed to recuse myself from this case, Judge.
All right, that wraps up today's video. I've got plenty of new content on the way over the next couple of weeks, including finally sharing the full story of a sovereign citizen who actually tried to take me to federal court and lost. Trust me, you won't want to miss that one. If you enjoyed this breakdown, hit the like button. If not, feel free to hit dislike. Either way, leave your thoughts in the comments below, and make sure you're subscribed with notifications on so you stay up to date with every new upload. Thanks for watching. I'm Team Skeptic, and I'll see you in the next one.
Be removed from this case because Mr. Peterson filed a motion on his own and not with discussion with you, and you're not comfortable with that motion.
That is not the sole reason, Judge. Mr. Peterson insisted that the only way that he would be comfortable with me representing him in this case is if I continued and persisted with this motion. I do not agree with the motion that he is filing, and he said that he would prefer to go on his own if I would not go forward with this motion in his behalf. And we had a civil discussion about this, Judge. We did not have a fight or anything. I want to make that clear. Mr. Peterson and I have a good relationship, speaking-wise, so I'm not trying to cast aspersions on him at any point. I want the record to reflect that. But this is an impasse that we have reached, and that is the reason I have brought this to the court's attention.
Okay. All right. The court will note that there was a motion that was filed today asking for this court
For the videotape, hearing a bell and charges.
Okay, we don't have videotape, you can request a transcript, certainly, that's, yes, you can certainly request a transcript. You don't need a motion for that, you can request a transcript without a motion, just so you know.
Okay, well, we did it over Zoom, so I just assumed that you'd have a videotape of it and not a transcript of the 7th, of January 7th, when we had a bail bond discussion and charges of trespassing and assault in the city of Woodhaven. We did it over Zoom.
I understand we did it over Zoom, but we don't, that was not recorded over Zoom. It was
just on
recorded
transcript.
on our transcript.
Okay, well, I'm gonna have to file a motion for that, I guess, because I don't.
No, sir, what I'm saying is that you don't need a motion for transcripts. You can just request the transcripts.
Okay, yeah.
There's a fee that you have to